Good morning. Please be seated. This is the time set for oral argument in crime victims RS and SE petitioners versus the Honorable Peter Thomson, Maricopa County Superior Court, real party in interest Teddy Carl Vanders, 1 CA-SA19-0080. Out of respect for counsel in the court, I ask those in attendance to please make sure your cell phones are off or on vibrate. Each side is allocated 20 minutes for argument. Appellant may reserve a portion of that time for rebuttal if you wish to do so, but you will need to keep track of the time using the podium clock. We have read the briefs, the petitions in response. We conferenced the case this morning. We are very familiar with the facts, but we ask you to keep that in mind as you present your oral argument. These proceedings are being recorded and will be posted to YouTube. So before you begin your argument, please state your name and who you represent. So if anybody watches online, they'll know who you are. With that, counsel for appellant, you may proceed. Should have said counsel for petitioner, you may proceed. I'm sorry. Petitioners. Plural.
Good morning.
Sorry.
You're okay. It's true. Jamie Balson on behalf of petitioners RS and SE. May it please the court. The court asked the parties to be prepared to address two questions today. I'll take them in order and stand on the petition regarding the remaining arguments. The first question was whether the victim's records can properly be invaded under the physician-patient privilege statutes. And the answer is no. The victim's records can't be properly invaded under these statutes. As a preliminary matter, in this case, there has been no waiver of the physician-patient privilege, either expressed or implied, nor has the defendant asserted that there was a waiver.
And is it fair to say that the records are in no way, shape, or form in the hands of the state at this
That
time?
is correct.
Okay.
Nor has the state seen them or been made aware of them?
That is correct. The question becomes whether the defendant's due process rights defeat the physician-patient privilege, and the answer to this, too, is no. Because what the defendant is required to show before requesting and obtaining a disclosure order from third parties is a substantial need, and that the records cannot be obtained in another way. And the defendant has not shown that here. He hasn't shown substantial need, which is a necessary component of not only Rule 15.1G, but also Roper and its progeny. He can't demonstrate that he cannot obtain the substantial equivalent through another means. He can testify to the alleged acts taken by the victim or her alleged propensity for violence, and his statements to the 911 operator certainly support the contention. He can call other witnesses to testify about the alleged acts or the alleged propensity for violence, including the officers from the 2009 and 2011 incident on which he is basing the present request. The petitioners raised this issue in both the trial court and in our petition, but it has remained unaddressed by the defendant. The court here is free to reverse the trial court on this issue alone and not invade the physician-patient privilege or violate the victim's rights under the VBR.
Well, and I really wonder whether the VBR is even necessary to the decision of this case.
I think it can be found on Rule 15.1G alone. I don't even think we need to reach the physician-patient privilege or the victim's Bill of Rights.
Well, 15.1G, though, has a fairly loose discretionary standard, right? And so I'm not sure that we can all come to the conclusion that the trial court abused its discretion under 15.1G. Is there a standard there that I'm missing?
Prior to violating, either invading the physician-patient privilege or violating the victim's Bill of Rights, the court has to hold the defendant to the standard. Can he meet the requirement? Can he get the information, through another means? That has to come first.
Well, I guess what you're arguing, though, is that he could get information that's likely to go to the same points. It wouldn't be identical, right?
Without having the records, I couldn't say.
But the real party in interest argues that the diagnosis, they need the actual diagnosis, and they wouldn't be able to get that through any other means. So aren't we past 15.1 at that point?
And if we are, the justification defense has to be information that the defendant knew prior to killing her. State v. Taylor said that 169 Eras 121. He didn't know the diagnosis before he killed her. The diagnosis now, if there even is one, if she was even seen by a psychiatrist or psychologist on that day, he wouldn't have known the diagnosis beforehand. So
Do we know that?
he has not asserted that he knows any diagnosis. He lived with her for 10 years or more and has not said that he had any inkling of what a diagnosis would be, that she was on medication, that she was seeing a provider. He could provide nothing to support the contention that there's information there that would be exculpatory and essential to his defense.
And I guess your argument would be if he did know the diagnosis, that shows he doesn't need the information from the medical records.
Unless, yes, based on what we know now, yes. So if the court is intent on reaching the physician-patient privilege here, it must make the analysis similar to the one set forth in Roper and its progeny. The court must weigh the proffered need for the records with the victim's established rights.
Do we need to weigh that if we're just looking at the statutory privilege with no implications of the victim's Bill of Rights?
I don't.
Doesn't the physician-patient privilege, although it has exceptions and it's subject to waiver, doesn't it protect every person's personal medical information?
Yes, it does, and it should.
It's one thing to talk about, after we enacted the Victim's Bill of Rights, to compare the state constitutional rights of a victim with the federal due process rights of a criminal defendant. But this statutory privilege is based on societal policies and other things other than giving victims rights. It has nothing to do with victims, basically. It has to do with everybody. Well, I think that Roper created this confusion that where it seems sensible enough to say, the federal criminal rights have to outweigh the state constitutional rights of a victim. But that wasn't what was at issue, it seems to me.
I agree, Your Honor. I don't believe that we need to go past the physician-patient privilege and even get to the Victim's Bill of Rights. I believe the court can deny, or rather reverse the trial court on the physician-patient privilege alone, especially here in this case, because no one's even claiming there was any sort of waiver in this case, which is a little bit different
the
from Roper.
balance that Roper wanted to do, this balance between the things, and in the case of a conflict, to declare for the federal constitutional rights of the criminal defendant. But we've discovered one case, I don't remember what it's called, but where this court declared that the state, under some compelling circumstances, could invade the physician-patient privilege as to a crime victim that had withdrawn their interest in the prosecution. That strikes me as wrong.
That's the Benton case. Are you familiar with the case?
I did read it over. I can't independently speak of it right now, though.
Okay. I mean, I suppose the concern that I would just build on Judge Thompson's question with is it doesn't seem to me that a qualitative weighing of interests either by the defense or the state is contemplated by the statute. So when Benton and Roper start talking about doing that, that strikes me as a fairly ad hoc way to decide cases.
Yes, Your Honor, because in order to invade the physician, or rather find a waiver of physician-patient privilege, it has to be in writing or during testimony, and we don't have that in either one of the cases here. So it should not have been invaded. And to Your Honor's point about it being a public policy issue, then what happens to the attorney-client privilege or the marital privilege if we're going to start finding ad hoc exceptions and invading these privileges based on, in Roper, an implied waiver? And I have questions about Roper. I have significant questions. Roper talked about how mentally ill the defendant was. So could he waive that? Could he even impliedly waive his privilege in that case. What was the circumstance? Was it knowing,
I think
intelligent?
you misspoke. You said how mentally ill the defendant was. I think you meant the
Yes,
victim.
I'm sorry, Your Honor. That is correct. I did mean the victim. If he was so mentally ill that they were having trouble with his multiple personalities and integrating them, sounds uneloquent, but which personality was making the decision at the time? Was it a circumstance where the doctor invited the Roper defendant in to talk about scheduling of how long the person was going to be in, or was it substantive information?
You're basically asking if the victim was competent in Roper, and we don't know.
Right, we don't know. So it's another question that is out there, because Bonfeld Davis v. Ditzworth said that, of course, third parties cannot waive the privilege on behalf of someone else. But also in Roper, that 15.1 is underneath it all, showing the substantial need and showing that the information couldn't be obtained through another means. Because if the information can be obtained through another means, there's no due process violation. They have access to the information.
Well, let me give you an extreme hypothetical, if I may. Let's assume that we have a murder case, and the question is whether X or Y committed the murder. And we have strong reason to believe that before dying, the victim revealed that information to a physician. At that point, do we have a Rule 15.1 right? And if we do, does that right rise to the level where the privilege itself might be unconstitutional as applied if the prosecution goes forward?
And I want to make sure I understand the question. So either X or Y committed the crime, and the victim told the physician it was either X or Y who committed this crime.
So in other words, the physician is the only living human who knows what the victim said the victim observed before the murder. And without that information, the wrong person could be convicted.
And what initially comes to mind is it's a dying declaration. Did it reach the level of physician-patient privilege? I think I would need to know more facts. Was it the person was being wheeled in and said it, and the doctor was the one who heard it? Was there that the doctor was in the middle of assessing the victim? I think I need more facts.
Let's assume it's fully privileged, okay? And in other words, there was consultation going on about the victim's condition, and the victim relayed the story of the crime, but the doctor was the only one in the room. And then the victim passes away, and we're left with really fundamental evidence in the hands just of the physician.
So it would be the state trying to get that evidence, then, likely not the defense trying to get that evidence.
Well, the state has charged the defendant in my hypothetical, and the defendant would rather see the right assailant charged.
Okay, so it's the other defendant then in that case. I would still say that the physician-patient privilege can't be invaded. However, if it was my client, of course, I would strongly suggest in that case we would have a conversation about waiving that in that case.
Okay. Thank you.
So what was subject to discussion in Roper based on the facts of the case, the physician-patient privilege isn't an issue in the case at hand. The defendant has not claimed physician-patient privilege was waived, nor was there any indication it was expressly or impliedly waived. The case can be resolved before even having to do any sort of balancing on 15.1G. The defendant has access to the information he seeks through other means, and he's not demonstrated a substantial need as required by 15.1G Roper and its progeny. If there are no more questions, I'd like to reserve the remainder of my time.
Please do so.
Good morning, Your Honors. Elise Funey from the Office of Legal Advocate on behalf of Teddy Carl Vanders. Today I will be discussing two main issues. The first issue is that the physician-patient privilege can be overcome, and Roper was decided properly on this matter. And the second issue I will be discussing today is that the trial court properly ruled that Mr. Vanders had met his burden under Roper and its progeny in ordering the in-camera inspection of the records. Roper and its progeny were decided properly for two reasons. One, the physician-patient privilege is not absolute. And two, the Roper court properly upheld the defendant's due process rights while creating multiple layers of protection for the victim.
Okay, let me start you there and trace through the elements as I see them.
Yes.
The due process, that you would concede, I take it, that there is no universal right to discovery created by the due process clause.
Yes, Your Honor.
Okay. So really what we have is Rule 15.1 to work with, correct?
No, Your Honor, I apologize. Perhaps I misunderstood your question. I think that there is a discovery right under the Constitution in that every individual is entitled to present a meaningful and complete defense.
You have a citation for that?
No, Your Honor, my apologies. I think perhaps I'm misunderstanding the question a little bit.
There's a constitutional right to what's called Brady material.
Yes.
My understanding is that's generally information that the state holds
Yes.
that could be exculpatory towards the criminal defendant. Beyond Brady material, I think it's universally been held that discovery is a matter of rulemaking in the courts, and there is no general constitutional right to discovery.
And I apologize, Your Honors, off the top of my head, I guess I don't know that and could obviously supplementally brief that if Your Honors wanted to.
The importance is because it's easy to put this in the frame of 15.1G, which is information from third persons that might be helpful to the defendant in preparing his defense. Now, there are rights to present a defense, constitutional rights to prepare a defense. But 15.1G is kind of a generic method of getting third-party materials. But it doesn't, by its terms, has nothing to do with the privilege or anything else.
Well, that's correct, Your Honor. And as the petitioner pointed out, 15.1 requires the parties to demonstrate a substantial need and that they cannot receive that information by any other reasonable method.
But you already have that information, don't you?
I'm sorry.
Go, take Judge Thomson first.
You already have the information about this person's prior behavior.
We don't, Your Honor. These medical records are specific as to an incident that involved Mr. Vanders and Ms. Stiegel. She was involuntarily transported to a psychiatric center as a result of what happened between her and Mr. Vanders.
Right, so Mr. Vanders was there, so he knows about it.
That's correct, but Mr. Vanders was not privy to what happened immediately following this incident when officers took her to a psychiatric center.
If she had been transported to a church and confessed to a priest, would you guys be entitled then to get the confession that she made to the priest?
Yes, because due process is the superior right.
So it would trump the priest pendant privilege?
It would, in the same way.
If it had been transported to a lawyer's office, would you be able to get any conversation she'd had with her attorney?
Yes, Your Honor, because due process is the superior right.
The problem with this whole line of argument is this postulate that any time the defendant requests information under Rule 15.1, that it's suddenly a matter of constitutional magnitude. And I don't find any authority for that proposition. In fact, I find the opposite, because the U.S. Supreme Court has held that there is no constitutional right to discovery, but rather discovery is a matter of legislative grace. And if that's the case, how can we say that a mere request for documents pre-trial is a due process right that trumps everything? Because if we do, what we're saying is that every defendant's request under Rule 15.1 will mow over the physician-patient privilege, the attorney-client privilege, the priest-penitent privilege, the marital privilege, and those privileges don't really need to be in the books, because if they're going to yield every time somebody asks for the information, they are never effective.
Respectfully, Your Honor, I don't think that's what Roper and its progeny has actually come to fruition. I think that Roper and its progeny have required a very strict reading of...
Roper only dealt with the Victim's Bill of Rights. We're talking about privilege broader than that now, aren't we?
Well, Roper did briefly address the privilege, but because the facts in that case, there was some indication that at least the privilege had been waived to some of those records, that the court really didn't get into a full discussion of that.
You're not alleging waiver in any regard. You're not alleging that the state has these materials, which seem to be both kind of open questions in Roper.
Or an exception.
We're not alleging that the state has these records. What we are making the argument is that essentially due process goes above. Due process supersedes. And
Okay, so you make that argument, and at one level you're correct. I think everyone in the room would agree that at some level due process supersedes. But what the dots you haven't connected are the dots between a request for documents pre-trial that is not constitutionally mandated, but authorized by rule, and due process. Because, I mean, this could be a really landmark case, because if that argument works, attorneys are going to be on the stand every day.
But, Your Honor, that is presupposing that in any situation where you have similar facts, you're getting the records. And Roper made it clear, and its progeny has made it clear, and the trial court made it clear that it's not in any situation, it's specifically fact-by-fact basis determinations.
Ad hoc.
It's not. It's on a strict reading of the law in congruence with a strict reading of the facts and in comparing the law that was created by Roper and its progeny, requiring that there is a burden that the defense has to establish before they can even get merely an in-camera inspection. And so they've established that very high burden, a burden that is not easy to meet and that's not been met by numerous cases. I can
only think of three sources of judicial authority to do what you want to do. Number one would be a waiver of the privilege. Number two would be an exception to the privilege. And number three would be that the statute creating the privilege is unconstitutional as applied in the circumstance. Other than that, I don't know what hook we have apart from the trappings of office to just say that a statute no longer applies. I don't know what power we have.
Well, Your Honor, I don't think certainly no one's asking to abrogate the statute. What we are asking is that in the facts of this case, similar to the facts in Roper, that those facts justify an in-camera inspection and they supersede the patient-physician privilege because the defendant is entitled to those records.
That's what you're arguing. Is
a matter of due process.
As applied to this defendant or this case, that the privilege is unconstitutional as to your defendant.
It is, yes.
Okay, so that's the third argument.
And I still don't understand what it is you expect to get from these records that you don't already know.
Well, Your Honor, obviously these records came immediately after an incident involving Mr. Vanders and involving Ms. Stiegel. In that incident, Ms. Stiegel...
Years before the incident that resulted in her death.
6 years prior to the incident resulting in her death. During that incident, Ms. Stiegel was physically combative with Mr. Vanders. The officers came in, noted that she had tried to had indeed broken open a gun safe, attempted to reach
Have all this information via his observations and the police reports already.
Yes, Your Honor. But what's important to note is that in that police report, Officer Stockton noted that the victim was acting both homicidal and suicidal. And when you have a notation that someone is acting homicidal and they're immediately transported as a result of those homicidal tendencies to receive psychiatric treatment, that those records are necessary when an individual later on becomes the defendant in a case having committed an act against that victim. I'm sorry?
Records of what?
Records either of any potential diagnoses or statements.
What is the diagnosis going to do for you?
Well, Your Honor, when you're dealing with individuals who have been the victims of domestic violence, there are certain standards, certain things in the law that we have put in place for victims of domestic violence abuse. We have the battered spouse defense. We also have 13-415.
Use other acts to prove those, assuming they're not relevant enough and not too prejudicial. But the diagnosis, I don't see how that comes in at all.
Your Honor, I think absolutely the diagnosis comes in if it goes towards the defendant's state of mind at the time.
In my mind, there's a gross confusion in various cases in Arizona about the use of conflating a medical diagnosis with a character trait. It goes back to what we used to call the Christensen defense, which was a defense where a defendant would say, well, I have this mental illness, but it's really a character trait, and I'm going to call it a character trait so that I can use it to show that I didn't have the mens rea for the crime. And that has been extremely limited, if not made go away by Mott. And then we have the Flagstaff murder case with Ryan that confused it further. But the point is, it's pretty clear in our law that you can't use a person's character to establish that they acted in conformity with that character on the present occasion. Why can you use a diagnosis?
Well, a diagnosis, I think, is different than just a character trait. A diagnosis comes straight...
That's the confusion, I think.
Well, and I think that might be more properly, answered by some...
Hypothesize, if you would, the best case scenario. If you got these records, what would they show that is absolutely critical to the defense? Give me a diagnosis. Schizophrenia?
I think schizophrenia...
so that makes it...
would be one potential. You could have borderline personality disorder. I'm sorry?
That bolsters the defense.
I think it would bolster a justification defense because you could hire either a blind expert or a non-blind expert to testify as to how people with those diagnoses do generally act.
Well, problem with that too. But,
let's respond to petitioner's argument, which at least on its face made sense to me, that the only way the diagnosis is admissible is if your client knew of the diagnosis, because the justification defense is based upon what he knew at the time that he supposedly committed these acts. So if he knew that she had this diagnosis, then maybe it's admissible, but otherwise it's not.
Well, if he knows all of the character traits but simply doesn't know the diagnosis, I think that is certainly enough.
Your blind expert just testified based upon his description of her character traits she would meet this diagnosis. Why does it matter that someone 6 years previously might have diagnosed him that way?
Perhaps that could be an avenue, but when we really think about presenting the best evidence, the Supreme Court in State v. Ford said that the defense should be furnished with everything that is possibly necessary to present the best defense.
But if it's privileged?
But if due process overrides that, yes, Your Honor.
The Supreme Court say that due process requires free-ranging discovery into everything regardless of statutory protection? Or did the Supreme Court say when you're having a trial, the defendant deserves an opportunity to present a complete defense?
Your Honor,
It was the latter.
Well, he does have an opportunity to meaningfully present a complete defense, but Mr. Vanders will be precluded from meaningfully presenting a complete defense if he's unable to obtain these records.
That's where I'm getting hung up, because you're arguing that a 6-year-old diagnosis is necessary to your defense. Absolutely vital, right?
Yes, Your Honor.
Okay. But you've already testified your client doesn't know about that 6-year-old diagnosis.
Doesn't necessarily know what the specific diagnosis is, that's correct, but does know that Ms. Stiegel received mental health treatment.
She knows that, you know that already, so you can introduce that if it's admissible, that she got mental health treatments. You could then bring on someone to testify, look, she went to the mental health, and based upon these descriptions, she meets the definition of bipolar disorder or something else. So how are you that prejudiced by the fact that you can't just bring in the doctor to say, yeah, we diagnosed her that way 6 years ago?
Well, I think just realistically putting that into perspective, if you have a jury who's listening to a blind expert who's never met the victim and who's relying on a few records to make their determination versus actually speaking potentially with the physician that diagnosed Ms. Stiegel, because we would get that information if it was essential and if it was exculpatory through an in-camera review and then through dissemination. But if that wasn't essential and if it wasn't exculpatory, it would never go past the gatekeeper.
Is it legitimate for a court to say that a victim's medical condition can be exculpatory? I mean, the fact that somebody may have a mental disorder doesn't make it okay to kill them.
It does not, Your Honor, but it does go towards a justification defense.
No,
and 13
what goes toward a justification defense are the circumstances that put the defendant in fear of some protected consequence at the time of the alleged acts.
And what he knew at the time.
Right.
Well, that's correct, Your Honor. The reasonable person standard under 13415 for an individual who's been the victim of domestic violence is the person who has been the victim of domestic violence. And so, yes, that is clear that could be presented, but without more, we don't necessarily have a jury that's latching onto that, and we don't necessarily, we're also forcing essentially Mr. Vanders to testify to these things when we should never force an individual to.
Necessarily, but you could call the police officers who were present back during the previous times when, back in 2011, as to what happened.
Right, but those police officers would only be privy to what happened while they were there, and they wouldn't be privy to what happened before they were there, and they wouldn't be privy to what happened after. And after is directly related to the incident involving Mr. Vanders and Ms. Stiegel.
Forgive me, but this is starting to sound like a typical discovery argument. And what we have here is something other than just a relevance determination. Your entire argument, as far as I can tell, hinges on the notion that the defendant's desire, or as you might put it, need for this information is of constitutional dimension.
Yes, Your Honor.
And that is where I have not found any authority. And I don't want to put words in your mouth, but I think you said you haven't either.
Your Honor, I think this is of a constitutional dimension, and the facts closely mirror Roper. And Roper, this court in Roper felt that it was of a constitutional dimension that required an in-camera inspection. When we evaluate this case with the facts of Roper, we note in Roper that the defendant called 911 saying that she'd been the victim of abuse.
But in Roper, the court didn't even know when it wrote its opinion if the material was in the hands of the state or not.
Your Honor, that might be.
And Brady, if it were in the hands of the state, Brady would make disclosure a no-brainer.
But, Your Honor, that is talking more about Brady, and Brady cases are really having to do more with instances where the discovery is in the possession of the state.
And that suggests that Roper may have gone on a bit more of an expedition than it needed to, because it didn't have the court then didn't have the basic facts necessary to know if there was a constitutional right or not. If it's in the hands of the state, there is a constitutional right to the disclosure of exculpatory information. We know that. But I didn't see anywhere in Roper or any other case a holding that a defendant's pretrial request for documents is either automatically of constitutional dimension or can become that way because of the feelings of a given judge or panel on a given day.
Well, I don't think that that's what this case is saying, Your Honor. I think in this specific case, it does rise to a constitutional dimension because Mr. Vanders established to the trial court that this information is potentially exculpatory and is essential to his justification defense.
Let's get back to the diagnosis you feel is potentially exculpatory. I don't want to re-argue that. What else is potentially exculpatory?
Your Honor, any statements that she might have made to providers regarding that specific incident or similar incidents. If you are being transported as the result of an incident, it is very likely that the provider is going to ask you direct questions about that incident. And so the trial court was proper in finding that you might have statements of similar action, statements regarding that specific conduct that could...
So is your position then that anybody who is injured by a violent crime and seeks medical attention does so at their peril because they no longer have the rights guaranteed by the privilege?
Absolutely not, Your Honor. Roper made certain that this was to be made on a case-by-case basis, a close factual determination. And when you have case facts that are similar to Roper, like you do in this case, it is in those cases that the defendant's due process rights do trump the privilege.
We are not bound by Roper, and we're trying to evaluate, number one, what Roper means, and number two, whether it was correctly decided. And the idea that we have to decide on a case-by-case, fact-intensive basis, I know we use those phrases when we can't articulate a rule, but it sounds like you're saying Roper didn't really articulate a rule, and we just have to be in the right frame of mind to find this important enough to override a privilege, which is a very dangerous way to run a court.
No, Your Honor. I don't think that that is what we are asking for at all. And I think that the Roper Court did make it clear that when you have two interests, and one interest is a federal due process right and a state due process right, that when those
define
interests...
that right for me again. What is the due process right here?
In this case, Your Honor, it is the opportunity to present a meaningful defense.
You have that full opportunity. Aren't you really arguing it's the opportunity to present a meaningful defense via obtaining discovery that invades a privilege?
No, Your Honor.
No one's denying you putting on whatever defense you want. What you're arguing you're denied is documentary or other evidence that would support that defense, right?
But, Your Honor, that is the meaningful opportunity to present a defense. If you present to a jury evidence, or you present to a jury evidence with supplemental evidence, with documentation, with support for your contention, it's a lot different to a jury's ears.
So then you are arguing, and in order to rule in your favor, we would have to find that there is a constitutional right to discovery, not just to discovery as provided under state law, because state law in this case provides a privilege. So we'd have to find the privilege unconstitutional as applied to you.
No, I think that you would simply have to find that in this case, the privilege is superseded by the defendant's due process rights under the Constitution.
Articulate a standard that you'd like to see in an opinion then, because right now, if we just wrote something, say, this is very fact-specific, but let us lay these facts out for you. There's a 6-year-old diagnosis, a diagnosis that happened 6 years before a conviction that the defendant doesn't know about.
Well, we don't actually know if there's a diagnosis.
Well, right. There may have been a diagnosis. The defendant doesn't know. It could be helpful, and that's enough to invade the privilege. If we set that as the bar by example, I can imagine that we would be very, very busy overriding privilege every day. So instead of setting it by factual example, can you offer us an abstract construction that would state the rule you have in mind?
Your Honor, I think Roper and its progeny has made clear that a defendant is required to establish a reasonable possibility that the information that he seeks is information that may amount to one of a constitutional dimension. And once he's met that burden, which is significant, the court in State v. Kellywood stated that is not an insubstantial burden. Once that burden has been met, disclosure simply for an in-camera inspection is warranted. And it's only upon a judge's affirmative finding upon that in-camera inspection that those materials are exculpatory and essential to the defense that any of them are disseminated. But that creates a rigorous two-step process for any defendant who is trying to get records like this. And it is a case-by-case basis, but certainly the facts in this case do warrant dissemination of those records merely for the in-camera inspection.
Jude would concede that giving those records to a judge breaches the privilege.
Yes, Your Honor, but it does so in a much more limited fashion than full disclosure. And this court and the Supreme Court have recognized that there is a difference between dissemination to all parties of materials and dissemination merely for an in-camera inspection.
And similarly, you would also say then that we should have priests come and provide statements to judges in camera so they can determine if there's exculpatory material there. Co-defendants' lawyers can be brought in to provide the same statements.
Your Honor, taking Judge Swan's example, when you have X and Y, if one of them had gone to a priest and ultimately it was determined by defendant X that perhaps she had told the priest that defendant Y did it, I think in that case the due process rights of the defendant would supersede. And yes, in that case, an in-camera inspection of those records, of those statements, of whatever it might be, would be warranted. But merely an in-camera inspection. We're not talking about automatic dissemination.
We'd have to have an in-camera court just to hear all these, because while this sounds like a modest request in just this one limited case, really the standard you're articulating would have every single co-defendant's lawyer producing material for in-camera review. Every single time, because I have a hard time imagining a case with two defendants, a criminal case with two defendants, where if the opportunity were there, digging around in your co-defendant's lawyer's files wouldn't be very enticing and potentially exculpatory. And all you're saying is the Roper standard, which requires a mere possibility. So that possibility exists in every single case, and it strikes me as odd that we would have coming up in this posture the first case in the country that I know about to declare a constitutional right to discovery. This would be a landmark decision that you're asking for.
Your Honor, I don't think that we're asking you to find that there's a constitutional right to prediscovery. What we are asking you to find is that when you have a patient-physician privilege, which is a state privilege, that is superseded when you have a federal due process right. And in this case, the lower court determined that Mr. Vanders did have a federal due process right that warranted an in-camera inspection of the records.
Federal due process right to discovery of these records.
No, a federal due process right to meaningfully present a complete defense and to potentially call an expert if that is necessary in the preparation and in the presentation of that defense. Roper was not an invitation for courts to go on a fishing expedition, and I don't think this court or any court has interpreted it as such. You have State v. Connor, you have State v. Kellywood, all cases in which the courts are saying, no, you are not getting the in-camera inspection of these records. No one is requesting to go on a fishing expedition in this case. Mr. Vanders has specific information as to when the victim was treated, as to where she was treated, as to why she was treated, and he's asking merely for an in-camera inspection of only those records. And it's because those records directly relate to a justification defense. If Mr.
Is his argument then that what he was thinking at the time of the alleged crime was, 6 years ago, I remember there was that medical treatment, and that medical treatment really formed a part of his mental state at the time of the event, something that had happened 6 years earlier?
Your Honor, I think the attenuation of time is something for the trial court to make a determination of.
For you right now, is that your position on behalf of your client, that this 6-year-old diagnosis somehow inspired him to do what he did?
Your Honor, I don't think that anyone could say a diagnosis that you're not privy to or you're unaware of inspired you to do something. However, what that expert can do is make a determination of those records and make a determination as to what he might feel that the victim was experiencing, how the victim might have reacted to certain things based on a diagnosis or based on the statements that she made.
I don't like it when the state tries people using hypotheticals, and I'm not sure that I like it any better when the defense tries to use hypotheticals either. When these blind witnesses testify as to what may have happened, what could have happened, what usually happens, it strikes me that that's an interesting constitutional debate for another day, but I'm aware of nothing to suggest that there's a constitutional right to gin up privileged information to feed to a blind expert so that they can wax poetic about hypothetical situations that other people who are not people in an issue in the case might have been engaged in.
Well, Your Honor, I think it also goes towards not just a blind expert, but to a specific expert who might be making an opinion as to a diagnosis of perhaps battered partner syndrome, battered partner defense. And in that case, certainly an expert would want to have documentation of past incidents or documentation of this victim.
They're getting the documentation of the past incident. You're just wanting also the documentation as to what she may have said after the past incident, which your client wasn't aware of.
Well, that's true, Your Honor, but that can still go towards the way that she treated Mr. Vanders, and the way that she treated Mr. Vanders is necessarily a part of the justification defense because the way she treated him then goes towards his mental state.
Doesn't he know that better than the doctor? Don't his associates know that better than the doctor?
But that would require him to testify, Your Honor.
Well, that's why I included his associates. Is there nobody else who's observed this long relationship?
Your Honor, requiring Mr. Vanders to find associates or to testify himself is not giving him a meaningful opportunity to present a complete defense when we know that there...
The right to present a complete defense means a right to present a complete defense without testifying? Do you have cases that support that proposition? I mean, there's plenty of times. Rule 609, for example. Defendants have to sometime testify in order to invoke their rights. So what's your support for that proposition?
Well, I guess what I'm getting at is that if ultimately we're leaving the onus on Mr. Vanders to present information about these past incidents, what we are essentially doing is putting the onus on Mr. Vanders to testify. And that is certainly in conflict with his rights.
Well, that's the right you want protected then, is present a complete defense without cost to my client.
No, Your Honor, it's not without cost. It's a meaningful opportunity to present a complete defense, and in
The
this
reason you can't get them
case-
otherwise is because your client would have to testify then. So that's the unavailability.
Not necessarily. I think there is certainly information in those records that my client could not testify to, and certainly information that would be better testified to either by the treating physician of Ms. Stiegel or by another expert reviewing those records after the fact.
Your entire defense is based on his state of mind at the moment. Who better to testify to that than your client?
Your Honor, perhaps that's true, but that requires my client to testify, and my client is not required to testify.
No,
and when
he
you
is
have
required to make strategic decisions as to how to defend himself, and the decision not to testify is a perfectly legitimate one. But it is a decision that carries consequences.
That's true, but in this case, when you have a separate avenue of access to get to these records, to get to the same information presented to a jury, when you have another avenue, why should we go down the avenue of requiring Mr. Vanders to testify and potentially to incriminate himself?
This has a legal right that seems to be just yielding to Mr. Vanders' strategic choices.
It's not yielding, Your Honor. It is a case-by-case determination, and in this case, the trial court determined that Mr. Vanders had due process rights that did supersede the privilege, but they don't.
Records on their way over to Superior Court for in-camera review, I would certainly feel that they had yielded, and I suspect you would too. To the holder of that right, it is a meaningful intrusion. And so you're saying that your client should be entitled to make his own strategic decisions at the expense of others' rights. I don't see authority for that.
Your Honor, due process is the superior right when these rights are in conflict with one another.
Okay. We're really low on time, but I have to point out, you have a syllogism here.
That's the understatement of the day.
Yes, you have a syllogism here. Due process is the most important right. That's the major premise. We get it. The minor premise has to be that this request is a matter of due process. And that's, again, the part for which I'm lacking authority.
Your Honors, it's a matter of due process because Mr. Vanders has a right to an opportunity to meaningfully present a complete defense under California v. Trombetta. And without this information, his opportunity to meaningfully present a complete defense in the same way that it was for the defendant in Roper would not be upheld. We have substantially similar facts in Roper and in Vanders that warrant this minor intrusion through merely an in-camera inspection only of the victim's records. And ultimately, when the defendant's due process rights are in direct conflict, they do weigh the day.
Thank you very much.
Thank you.
Just briefly, Your Honors, I need to correct the record. The defense indicated that the victim was involuntarily taken for treatment. She was voluntarily taken. The officer had a discussion with her about her suicidal ideations. The request here by the defense was that they want all of Ms. Stiegel's mental health records because it is evident that Ms. Stiegel suffered from mental illness and had suicidal tendencies. This homicidal language has come up later, not when we were originally arguing this. And to that point, I won't get too far afield. There was a 404B hearing in the trial court after we had filed our pleadings here. And the court pressed the defense on this issue and said, now you're saying homicidal. What homicidal? You're saying there's homicidal information that she was homicidal. The only thing that the defense could point to was a statement by the officer. The officer said suicidal and homicidal ideation. There was no other information that the word homicidal or that there were homicidal tendencies. It's clear there was something going on. She was suicidal, and you see that in the petition. But to say that she was involuntarily taken for treatment when she voluntarily went there for her suicidal ideations just misstates the facts. The showing necessary to permit an invasion into the victim's privilege and constitutional rights is very high. It must rise to one of constitutional proportions. The defendant here hasn't met the burden. And
You would agree, though, that there are some cases in which it could.
in which it could invade the privilege or the
Well,
constitutional.
like Judge
Which it
Swan's
could rise-
hypothetical to you.
Yeah, it could rise to constitutional dimension to the extent that the Constitution would be offended if the privilege were upheld. In some extreme case, that's a possibility.
So I anticipated that question, and I tried to think of a time when I would find that to be true. And unless the defendant can show that he cannot obtain the information through other means, that it's not phishing.
About my hypothetical, in the ER, the victim comes in, does the dying declaration in the midst of treatment, and identifies the person when law enforcement has multiple suspects. And the risk of an erroneous conviction is high, but could be completely eliminated by requiring the doctor to testify. You'd say, we'll go with the erroneous conviction?
Well, that presupposes quite a number of things to reach the conviction from. That would presuppose the state doesn't have much other
Convictions aren't as
information.
hard as they sound in a lot of cases.
I still say that the physician-patient privilege would have to stand. Now, the state can.
We would knowingly then subject someone to a statistically overwhelming risk of erroneous conviction to maintain the doctor-patient privilege. That sounds like a very limited reading of the Due Process Clause.
But in between, see, I'm not saying it's all black or white. There's a lot of in between information that could happen there. Did the
And you're
state
conceding
speak?
what they're arguing, which is that there is a balancing test that needs to be done, and at some point, if the finding is sufficient enough of their need to present a defense, then the court can limit, or on a very limited basis, to conduct an in-camera review to determine if there's something there.
No, I'm not conceding that. What I'm saying is, based on these facts here, we can't answer that hypothetical because there's so many things that could happen to get that other information. The state can work with the next of kin. There are other steps that need to be taken to show that the information cannot be obtained through another means.
Well, let's say that the victim asserts all the victim's rights, or the victim's family asserts all the victim's rights, and has no interest in participating in any way, shape, or form with the investigation or the trial or anything. And we have somebody who statistically faces, let's say, a 2 out of 3 chance of being wrongfully convicted. That doesn't reach your threshold?
Well, where's the co-defendant? Is the co-defendant going to testify?
The question is, only one person's been charged. The question is whether it's the right person. And that's the only issue in the case, is whether it's person A, B, or C. You charge person A, but you may have information that suggests that person B and C does it. Are we really ready to reduce the standards for conviction that low?
See, and I'm having trouble even reaching your hypothetical because how did they get that information? How did the information come out if it was only between the physician and the victim?
The physician says, in a very poignant moment, right before death, I learned information that I don't feel comfortable sharing because of my medical license.
That
I
could
told
be.
you it was an absurd
yes,
hypothetical. It's out there, but I'm trying to determine if there's any point at which this solid line becomes a dotted line.
At any point at which the privilege would have to, the due process right of the defendant would overcome the privilege.
Correct.
And I've not been able to think of a
So
hypothetical.
my hypothetical doesn't do it for you.
There's too many variables. And that was one thing that Roper did say, that it's intensely fact specific. And I think
Which
that
is
part of it.
Which is a rather poor way to write a legal standard. That's why I'm asking.
Yes.
Are you just saying it's an absolute bar, period, end of story, can never get to it? Fewer empty beds in prison is a price worth paying for upholding the privilege.
No, that's not what I'm saying. What I'm saying is it's difficult to imagine a hypothetical where the physician-patient privilege would not be upheld and not be protected. because I can't imagine, in the law, we can never say absolutely that one thing won't happen or not, and that's just
Well,
the nature of the
I
law.
myself to imagine my rather far-out hypothetical, but at least you acknowledge that there might be a hypothetical, even if it's not mine, that could lead to that result.
In the law, nothing is absolute.
Okay, fair enough.
Thank you.
Thank you. Thank you for your petitions and briefing and presentations here today. We'll take the matter under advisement and issue a written ruling in due course. We are now at recess.